From Miami Law, I'm Annette Uguez, and this is The Explainer.
Parties decided to instead direct that money to about 6 charities, 3 of which are internet centers at Harvard, Stanford, and Chicago, Kent, were alma maters of the attorneys litigating the case.
At the heart of Frank versus Gaos, a case before the Supreme Court, is an $8.5 million settlement in a Google privacy case, which ended up squarely in the pockets of everyone except those who were harmed by the violations committed by the tech giant. Today on our show, class action expert Sergio Campos untucks not just the money trail, but the why of the award and the case before the court. Let's go to executive producer Catherine Skibb for the interview.
Good morning, Sergio. Thanks for joining us.
Thank you for having me, Catherine.
Good. So let's start out with the case that started all, Gaos versus Google.
Okay, so this is a internet privacy case involving the use of referrer headers. From what I understand, this is definitely not my area of expertise. Google, when you search for a website or search for something on Google, Google will spit out some links that you can link to. If you click on those links, what Google will do is redirect you to that website, but also include what's known as a referrer header, letting that website know how the user got to that website. And it'll have information like they use the Google search engine, and it'll also have information about the search terms that were used. And that's it. This case arose because there was some concern by the plaintiffs, and this is alleged by Paulina Gaos, who's the name representative in this case, that vanity searches, like searching for yourself, this information was being sent over to third parties, and this information was being used to find out information about the searcher. Mm-hmm. And this would be an invasion of their privacy rights. They filed a lawsuit asserting some state law privacy claims, as well as a violation of the Federal Stored Communications Act, mm-hmm. which allows for recovery of $1,000 per violation, as well as attorney's fees. So the lawsuit was brought. The class was estimated to include well over 100 million people. So there was a settlement that was agreed to by the parties for about 8.5 million, and 2 million, about a quarter of that amount, was to go to the attorneys as part of their fees. But rather than distribute the rest of the money to the class members, the parties decided to instead direct that money to about 6 charities, 3 of which are internet centers at Harvard, Stanford, and Chicago, Kent, were alma maters of the attorneys litigating the case. They, in order to get a class action settlement, you need approval from the court. And despite some misgivings by the lower court, they decided to go ahead and approve this Cypre settlement award.
And Cypre means?
So Cypre is a trust concept, and it comes from the French. I'm not going to say the entire phrase, but it roughly translates into as near as possible. And this arose in a context of charitable trust where you could not, let's say that the donor wanted the money to be used for something, but it was impossible. And therefore, courts developed these doctrines to try to approximate as close as possible what the donor wanted to be done with the money. Mm-hmm. And so courts have imported this trust concept into the class action context to deal with this pretty common situation. And the situation looks like this. You have a class action settlement. Mm-hmm. The amounts are very small per class member, and there's anticipation that not every class member is going to put in a claim and recover. And so there's going to be leftover money. And so what do you do with the leftover money? In the past, courts have experimented with maybe putting the money, what they call fluid recovery, where you would give the money maybe as a form of a discount to others that weren't necessarily the class members. Mm-hmm. Courts hated this particular approach. So what has become accepted is this Cypre approach, where basically what courts have done is use residual funds that were unclaimed, and give it to charities whose purposes were close to rectifying the kinds of violations at issue in the litigation.
Mm-hmm. But in this case, none of the money went to the class members.
Right. This is what makes this case pretty unique. this is very rare to have what's known as a full cypre settlement. A Harvard class action expert, Bill Rubenstein, filed an amicus brief, or friend of the court brief, where he provided some interesting statistics about the prevalence of full cypre awards. And I think for the past 10 years or so, he included a table, there's been maybe one, at most two approved in the entire United States. I think there's something along the lines of 18 approved total in the history of federal court practice.
Thousands and thousands and thousands of cases.
Right. And so this just does not happen very often at all. But when it does happen, it is a little, I think it causes the courts to worry. And those worries were really in full display when you get to the oral argument before the Supreme Court in this particular case.
In Frank versus Gaos.
In Frank versus Gaos. So before I continue, let me talk a little bit about who Frank is. Frank is Ted Frank. He's a member of the class, but not one of the named representatives. And the way the class action rule works is that you have one member of the class who is the named representative act on behalf of the rest of the class. Frank was not named, but Ted Frank has this interesting practice where he's an objector in many class actions. What ends up happening in a lot of class actions, if there is a settlement, there's an opportunity for individuals of the class to make objections, saying that the settlement is unfair or unreasonable. And Frank has done a pretty valuable service in terms of being a kind of objector in many class action cases and pointing out significant flaws in the recovery.
How can he, though? Is he just like a curmudgeon, or does he actually have a dog in any of these fights? Like, how is he impacted by all these different kinds of class action suits?
So it's interesting because by definition, most of these class actions are class actions where the recoveries are very low for each of the class members. And so it's not like Frank as a class member would have a pretty significant financial stake in any of this.
Right.
I think he just cares a lot about the issue. And I think he really cares about, from my observations and his conduct in other cases, I think he's worried about class members not being looked after or not being cared for in these types of negotiations. They're a particularly vulnerable set of individuals because, by definition, if you're going to have a class action with monetary remedies like damages, it's usually going to be in situations where the amount of money at stake is small, and people just aren't going to have the incentive to care. And the people who are going to care are the defendant, who wants to get out of the liability, and the class action attorneys who want to make a lot of money. And so if you're not careful protecting the class members, there's this fear, I'm not sure how well-founded it is, but there's this fear that you'll have situations where the plaintiff's attorneys and the defendant will come to some sort of agreement where they will benefit at the expense of the class.
Right.
And I think that bothers Ted, and that's why he gets he's actively involved in a lot of this litigation.
Okay, my other question would be, for instance, Netflix or your cable provider. If there's a settlement, then why is there ever money left over? Why isn't it just divided among, I think I got something from Netflix where I had, like a credit or something along those lines that was paying out on a class action suit.
Sometimes it's easy, and sometimes it's just simply a matter of the defendant having a record of the victims and just simply giving them a credit. But in a lot of cases, you see this a lot in the context of consumer type cases where you have individual purchasers buy something. You need a little bit of proof to figure out whether you're a member of the class or not. Like, did you buy the product? Did you buy the pill? Did you do this? And once you have a big enough class, it gets really expensive to identify these people, really expensive. And it's hard to come up with a claims process that is streamlined enough so that people will actually take the time to recover, given how small the amounts are. And I think, as anyone who's ever had any experience receiving these class action notices, you usually have to fill answer some questions and fill out some forms. And even that might be too much to get your $10 or your $5.
Right. Class action 101.
Yeah.
Perfect.
And so, so what ends up happening in a lot of these cases, and this is a prime example, when there's a situation where it's too costly to identify the actual class members so that they can actually distribute the funds to them, courts have concluded that the money or the efforts may better be used to provide indirect benefits in the form of cypre to charitable organizations that do the kind of things that were at issue in the litigation.
Got it.
So, so the belief being that they should get at least something. In this case, the court believed that with 8.5 million total, or 6.5 million available, and there's in a class of about 100 million people, you're talking about recovery about 6 cents or 7 cents per class member.
Is that why there was no payout to the class whatsoever?
Well, that's what
because of that distinction?
Right, and that's what the lower court concluded. Although Frank argued at oral argument that what ends up happening in a lot of these cases is that you are going to have maybe like a subset of the class members who really care, and you can give them bigger awards without the risk of not being able to compensate everybody else. Mm-hmm. And so Frank made this point that the infeasibility of providing compensation, the court sort of didn't take into account the possibility that you could have bigger awards for a smaller set.
Right. Okay. So the Supreme Court heard the case in October. Was there any tipping that might have shown which way they're going or which way some of the justices may be leaning?
So we have a little bit, and this is just based on following the court for a while on class action issues. We do know that Justice Roberts is not a big fan of cypre awards, and he wrote a separate opinion in a settlement involving Facebook where the court decided not to take up the case at the time, but he said we really need to get a handle on these types of cases. Mm. And based on his questioning in this case, it's pretty obvious that Justice Roberts is not a big fan. I actually pulled out all the 9 justices and tried to map out where I think they're leaning based on their questioning. I'm going to leave Justice Thomas aside because he never asked questions at oral argument. He's probably not a big fan of these types of these settlements. So this is what I could sort of glean based on listening to the oral argument and sort of reading about the case. On the one hand, you have Justice Sotomayor and Justice Breyer, based on her questioning, sort of taking a tack like, well, yeah, there's some issues with these types of these settlements, but they don't happen very often. And here, Sotomayor had cited that Rubenstein brief I mentioned. And for that reason, it seems like the system's working. And if they're using the same rules that we've always used, then this should probably be fine. Mm-hmm. You have sort of a middle pack, and this is where things got interesting and where a wrench was kind of thrown into oral argument. Both Justice Kagan and Justice Gorsuch brought up the issue of standing. Now, standing is an issue, it's a technical issue that has to do with whether someone can bring a case into federal court at all. Mm-hmm. So it's a threshold issue, what they call a jurisdictional issue. And in order to satisfy standing, you have to show, among other things, that you've not only asserted a legal violation, but there had to be some sort of personal harm that you felt. And the reason for this, there's a lot of policy reasons for it. Separation of powers, you want to make sure that you have claims that are appropriate for courts rather than legislatures. There's also, you want to make sure that parties are sufficiently motivated to litigate the case and develop the facts and the law for the courts. But in any event, you have to show not only that there was a legal violation, but that the plaintiff was personally harmed. Mm-hmm. And the courts reiterated that in a very recent class action case around 2014, 2015, Spokio v. Robbins, where the court said it's not enough to show that there's a violation of a federal statute. You have to show that you were actually hurt by this. Mm-hmm.
That's come up a lot recently on the emoluments. Correct?
Right, yeah. And
who has standing to bring suit against the Trump organization?
And it's funny you mention that because I taught a little bit of the Trump emoluments case that's right now in the the DC Circuit. And that's been a major preoccupation, although the plaintiffs, I think, were able to clear that hurdle.
Right.
They were able to show harm. So here's a difficulty that the justices were having in this case. You do a search on Google. A referrer header is sent to the third-party website, but the only information the header has is that those terms were searched on Google. It doesn't have any identifying information about the person. And moreover, in privacy is this great exception where a disclosure of true facts can be considered harmful if they're private. And you can think of a number of examples where that's the case, like family, interfamily disputes or interpersonal disputes. And so here, the court was skeptical as to what could even if you could trace back the search to the person searching, they're skeptical that anything the person was searching was actually private in that sense. You search for your name, you find links about your name, that's completely publicly available. There's nothing private about that. And the plaintiffs made this argument. They focused on one class member by the name of Anthony Italiano. And Anthony Italiano did some searches about himself and his soon-to-be ex-wife. And they made the argument that if these cluster of referrer headers would allow a third party to infer that he and his wife were about to be separated.
Okay.
And there was some sympathy towards that kind of harm. But apart from that, there was very little developed below in the lower court as to the harm that was suffered by any of the class members other than Italiano. And the court, when deciding the jurisdictional issue, had decided it before Spokio was decided, and so did not address the separate issue of harm apart from the legal violation.
Got it.
And so you had, Kagan, Justice Gorsuch, and Justice Ginsburg, mainly Ginsburg and Kagan, sort of suggesting that the best alternative route would be to simply give the case back to the lower courts and figure out the standing issue.
Okay.
And there seemed to be a compromise by the justices where they asked for additional briefing on the standing issue. And I think the order was sent shortly after oral argument in late October, and the briefs are starting to roll in.
Okay.
So you have like a middle cluster. I would lump Ginsburg, Kagan, Gorsuch that would probably use standing as a way to sort of not deal with the underlying issue of Cypre.
Right.
Now you have sort of a nice cluster of, I would include Roberts, Alito, and Kavanaugh, who really focus, I think, on the real danger that you have with these types of Cypre awards. And the real danger is that you worry about these massive conflicts of interest that could arise, particularly when you're trying to identify the beneficiaries for these Cypre awards. As Frank points out in his opening brief, 3 of the 6 recipients were alma maters of the attorneys. You also, another recipient was a charity that Google had contributed to in the past.
Okay.
And you saw in the questioning, particularly from Alito, some concern that you're going to set up a situation where the judge is going to have a preferred beneficiary, and the defendant's going to have a preferred beneficiary, and the plaintiff's going to have a preferred beneficiary, and they're essentially going to be indirectly enriching themselves by having funds to donate that otherwise would have come from their own pockets, which would be a disaster. Because one thing that I think one sort of underlying agreement among the justices is that just simply giving the money back to the defendant would be a bad idea because you want the defendant to be held accountable for any of their wrongdoing. And so there is some risk among this core group of justices that they're going to really come down hard on Cypre. The one interesting thing that came out of the oral argument, I thought, was some questioning by Kavanaugh, where he was picking up on some arguments that were made in the briefs and some suggestions by Frank in oral argument, so Frank says maybe you could have a distribution scheme where not everybody gets to recover, but some amount of people get recovery. And Kavanaugh suggests, well, why don't you have a lottery system where you identify some members of the class and just give them the money? Mm-hmm. And on oral argument, the attorneys for Google and the plaintiffs, the Gaos attorneys, sort of said, well, that's completely strange. And Kavanaugh said, it's no stranger than giving the money to people who are completely unrelated to the litigation.
Right.
I'm not sure if that's going to make an appearance in any opinion that comes out of the court. I doubt it, but it's an interesting thought, and at least suggests that it suggests, at least for Kavanaugh, consistent with Roberts and Alito, they just really it's hard for them to really support this idea of cypre at all.
Mm-hmm. Well, we'll keep an eye on this and get you back on the mic when we see the decision handed down.
Great. I really enjoyed this. Thanks for having me.
Thank you.
Thanks for joining us at The Explainer. On next week's episode, we will be examining the relationship between President Trump and the media. Our show is engineered and edited by Christopher Alzadi, with theme music composed by Ray D. Kim from the Frost School of Music. I'm your host, Annette Uguez. Today's show was brought to you by the annual Hospitals, Healthcare Services, and Access course, a multidisciplinary study with top experts in the field, including University of Miami President Julio Frank. For more information, go to law.miami.edu and search healthcare law.